questions in the room or online, feel free to email the clerk, Jackie Charles, or alternatively put up a comment on the YouTube live stream, and we'll endeavour to answer the questions as we go so that there's a level of interaction. So Bianca, briefs to do what?
I think it's interesting some people think that there are two types of briefs, a brief to advise or a brief to appear, but there's actually quite a multitude of purposes in which you can brief a barrister. It might be to advise specifically in conference in an informal manner. It might be to provide a formal legal opinion. It might be to advise only on evidence or specifically on prospects, or within prospects it could just be quantum. You might brief a barrister to draft or settle a particular document, whether it's related to settlement negotiations or pleading. You may brief them to act and appear generally. Something worth thinking about is the role in which barristers might be able to assist you in altering client perceptions. If you have a long-standing relationship with the client and perhaps the news that they need to receive is not extremely palatable, it may be that a barrister is well suited to give that advice. And similarly, a barrister can also provide a second opinion as required.
I think it's probably worth asking yourself why you want a barrister at all. Most people who are in the room will be lawyers, I imagine, or studying law, or at a paralegal or graduate stage. So what do you need them for? What do you need us for? Do you need someone with particular experience? Is it a defamation case? Is it a class action? Do you need someone who's very well versed in statutory interpretation or stamp duty? And identifying that person will bring efficiencies to the case pretty early on, because they won't necessarily need to read in to the area of law that you're asking them to give advice about, or to prepare pleadings in, or to appear in. They'll also, you should think about things like, do you need someone who has a lot of trial experience? Are you after a trial advocate? Are you after someone who has appellate experience in particular, or who's a good paperwork junior? And think about the type of case that you're actually asking the barrister to be involved in. How much is it actually worth, do you think, having assessed the likely quantum? Does that require a silk? Does it require a senior junior? Does it require a junior junior? Does it require maybe one barrister and they can be very junior because it's not worth that much, although it's worth a lot to the client? What are you actually going to be able to get back if you win on a taxation on costs if you've briefed 3 counsel and the case really needed maybe one senior junior and not an eminent silk and a senior junior and a junior junior to be there for a 2-week trial? So those are sort of some of the things that I think you need to think of at the very start, immediately after you start to think about what the client actually needs and how you're going to best service the client. It might be also a case of who can turn the work around quickly and who can turn it around quite fast. Certain people have very good reputations for being able to turn around paperwork very fast. It might be that people who have very good reputations are very unavailable. So availability, and this is going to come to a sort of loose initialism that I've heard time and again, and it's the 3 A's. When you're selecting counsel, you want someone who's available, affable, and able. And I put it in that order because ability is in spades usually at most bars. You can find someone who's clever enough to do the job, but you want someone who is actually available to take the calls, to respond to emails, to actually do the preparation, do the work, and who isn't overcommitted. And you want someone who is affable. A different judicial officer. So the 3 A's come from one particular judicial officer in Victoria. A different judicial officer said that he had a no arsehole rule when briefing counsel. You want someone who is easy to work with, who you enjoy working with. At the end of the day, you're coming to work trying to do a good job for a client, and working with someone who you want to speak to is kind of essential. And to reinforce Bianca's point about client expectations, the other thing that I think it's worth thinking about when you're thinking about whether or not you need a barrister is your relationship with your client. Is it someone who's just come to you for the first time and who you don't necessarily have a long-standing commercial relationship with, or is it someone who you have a long-standing commercial relationship with and you can use, frankly, the barrister to take the bullets for giving hard advice? It might be someone who you don't want to break that commercial relationship with them. You don't want to be the bearer of bad news, and we're pretty good bearers of bad news because we return the brief after the task is done. So on that part, and then do you want to say something about generally or specifically retained and the different types of things that you can get a barrister to do?
Sometimes I'm specifically retained, but then I have something in the cost agreement that just says, or other tasks are requested by you, because it often never ends after the specific retention. But yes, there's different ways in which, as I said earlier, you can brief your barrister. And so if you have something very specific and discreet that you wish to engage them for, that is something that you need to think about, as opposed to, say, an ongoing commitment for the 2 years of perhaps a matter in which it will proceed to hearing.
And the implications of deciding whether or not to select a particular counsel for a particular task versus a general retainer. So counsel are only required to accept a general retainer for, say, a period of about 12 months. It's not an ongoing thing and an expectation unless you're saying you're generally retained in this matter up until trial, and that's the basis upon which you actually brief us. It's also the case that once a particular task is done, you need someone to do an interlocutory application or to settle some paperwork of some sort. Once it's done and you call back in 2 weeks' time saying, actually, there's something else, we're not obliged to take that further brief. It's subject to the same rules that operate when we're actually accepting work, which is availability and fee and the like. However, there's a quirk to that, which is that it's a convention that you do call the barrister who you previously briefed back and say, are you still available because I've got another part of this case for you. Role of the barrister.
Yeah, as you might already all be aware, I'd just like to emphasise that barristers are specialists in advocacy and specialists in practice and procedure. We can also be specialists in particular areas of law, but in terms of the way in which we work as a team, they're the main aspects that we will take character of. It's to be remembered that the paramount duty of barristers is to the administration of justice, but that we must also represent our clients honestly and to the highest standards, unaffected by personal interests. The paramount duty to the administration of justice is something worth bearing in mind when you prepare a brief, because a barrister cannot just be a mere mouthpiece for their client. We must have all of the available information to us in order to comply with our ethical obligations to responsibly use the coercive powers of the court. And there are barristers' rules which sometimes I do need to advise instructing solicitors about, because they set out, so the barrister's conduct rules, for example, set out the work of a barrister and the work that a barrister cannot do. So, for example, we cannot file or serve pleadings. We cannot be made to be a witness in a case, which means we cannot be having a witness conference without our instructing solicitor present, or attend a site view without our instructing solicitors present. There's particular roles that are set out in those barristers' rules, and they're worth keeping in mind. And I think that just reinforces our role as independent advocates. And that fresh set of eyes that comes to your matter is established by being given the entire picture.
So you can sort of think of us, I suppose, as subcontractors. We're part of the team, but there are certain rules, as Bianca's outlined, that are worth sort of having a look at some point, to identify that we're not necessarily going to agree with what the client wants, and that's part of our ethical obligation. So the brief, and I think this is probably of use perhaps more to people who are at the start of their journey in the law than very experienced practitioners, but what do you actually include in a brief? Now, I think there are some templates in the room that have been handed out. This is a bit sort of functional, but it's nonetheless worth, I think, addressing. So you'll have an index in front of you and you'll have some chronologies, and I'll talk to those first and then we'll have a discussion about observations. So an index, it's incredibly boring, but it's pretty essential to work out where everything actually is in the material. The horror stories, and from a client's perspective, the horror stories of a shoebox of material turning up with perhaps very limited instructions saying work out what the case is.
Or emails, forwarded emails, and then there's emails within the emails, and then PDFs within
attachments to those internal emails. It's pretty inefficient in circumstances where we charge by the hour in most cases to not have a well put together brief with a thoughtful index. So you'll see that this is actually set up in sections or topics. So you'll have a section which just has the actual index, observations to counsel, and we'll go through what I would expect observations could helpfully include. Chronologies, and the two types of chronologies that are in the template that we've sent around are a chronology of the actual matter, that is the underlying dispute that's the subject of the advice or the work that the barrister is doing, and then a chronology of what is actually taken place in the dispute, which is more relevant as you progress through a matter than at the very start, but it's worth including at the very start and giving word copies to counsel as you go. Pleadings. So if you're briefing someone immediately before trial to appear as an advocate just for the purposes of trial, they'll need a copy of the statement of claim, they'll need a copy of the defence or wherever the latest pleading is up to, whether that's the second further amended statement of claim and an amended defence to that, replies, cross claims, defences to cross claims, requests for further embedded particulars responsively, which often take the form of letters now.
And in that regard, ordinarily where you might order something chronologically, if pleadings have been amended and it is the 9th hour, and even if it isn't the 9th hour, my preference is that the amended pleading is at the top, as opposed to, you start reviewing it in order and you don't look ahead and realise, oh, that's been amended and now I'm doubling up with my review work. So that would be an exception to the rule of organising them chronologically.
Yeah, absolutely. And I think depending on which jurisdiction, you may have sort of timetabling orders. That kind of timetabling order considered in a separate section. So what you should glean from the index, and this is not necessarily the way that everyone will want to do it, is that it's actually thematic, or at least not entirely chronological. And by that I mean that if you had everything chronological in an index, it would start with whatever started the dispute and end with whatever you currently are doing right on that day. And that's not the most efficient way to get counsel across the matter, and also for you to think about the matter, I think. I'll just sort of note that there might be a section which is obviously the evidence, but I'd draw your attention to the critical documents section. So depending on the type of matter, and it is contextual, you can have, particularly in large commercial matters, thousands of documents. One of the things that will make the process more efficient is not requiring counsel, who at the end of the day are human, even if they pretend otherwise, to wade through 4,000, 5,000 documents to try and work out what's going on. The distillation of your case, because you're the one running the matter, is a matter for the solicitor to take under their control and say, we think the top 25 documents that you need to be across are these. It's the contract, it's the letter terminating the contract, it's some of the correspondence back and forward, or it's in defamation, it's simply the publication that actually had contained the defamatory matter, or in a class action, it's the ASX release that said, we're going to meet this guidance, and then it's the corrective disclosure, and then it's the statements from the market showing that actually, as a response to the corrective disclosure, the market fell 50%, right? So working out what the absolutely critical integers of a claim are will lead you to understand what critical documents need to be included in the brief. At the back end, authorities and legislation. Now, some counsel have a different view about whether or not they want a separate authorities bundle. I think the best thing to do, and I certainly do this as a matter of practice, is someone calls me and says, we'd like to brief you in such and such. Great, wonderful, excellent. Can you please send me a draft copy of the index before sending me the brief? People sort of go, oh, that's a bit strange. And that's because I can try and carve away things that I think I probably don't need to read that will cost the client money for me to read. And it also means that I can have some control to some extent about structuring things in a way that work for me, which is just more conducive, I think, to getting a pretty efficient and effective resolution of whatever the task is that I've been briefed to do.
I have a slightly different experience.
Oh, good.
It might be that I'm much more junior, but
Not really.
Well, I am more junior. I've been in situations where it's made sense. It's been cost effective for my instructor to hand over
All the documents,
and for me to work through it and work out if there is a case or if there isn't a case. So even though that goes against everything that we're saying about perfect briefs, it actually makes sense sometimes, depending on the charge out rate of an instructing solicitor or their team, the capacity of the team, to actually hand over. But with that, that disclosure and that conversation with your baby barrister, that in fact that's the situation, and I was more than happy to assist in that regard because it took the workload off a more expensive lawyer. And the task needed to be done. But I still support all of the principles that we are discussing.
No, I'd make two further observations on it. The first is that if it's going to be done that way, which is fine, then ask for it in chronological order, because nonetheless you're still being asked to work out what is going on and what to do. And the second thing is it actually connects to an observation that Bianca made earlier, which is what are the client's objectives in using a barrister? And it might be that they're very cost conscious. It might be that someone at the junior bar who actually more often than not will have quite a lot of experience as a solicitor before coming to the bar, especially these days, will be much cheaper to brief out the preparation of things. So if the client's particularly cost conscious, I think that's worthwhile contemplating at the very start. I do a lot of class action, so it doesn't tend to be a massive concern of mine, but it will be for a number of clients and a number of solicitors.
In terms of, sorry, yes, no. I think in terms of the inclusion of critical documents, I think that's a really good point, Owen. Something I used to do when I was an instructor, and now I'm grateful for when people brief me, is I'll list what I think is essential reading for my barrister. I did. I'm just still getting used to saying that on the other side. Now when I receive it, but having that additional list, because you as the instructor, you receive so much more and you absorb a lot of the nuances of the client and the subject area. And so saying, by the way, I've got another entire list of documents here, let me know if you'd like them, means that it's been addressed, but you haven't just then passed it on. And you just don't always know what is or isn't useful to a barrister. But making that forensic decision is an excellent exercise. And then we can always call upon those additional documents if we think they might be worth reviewing. Correspondence that is not controversial is, I think, rarely relevant to counsel. But again, it's a case-by-case situation where you need to make those determinations. And sometimes you're just wading through papers. But again, just limiting it to what is critical is a great assistance. In terms of your views, please put them forward at all times. I don't know if I'm jumping ahead to observations.
No, let's do observations.
Please put them forward at all times. Even if you're unsure, you can just say that you're unsure. For example, if it's a matter of statutory construction, but you think you're on the edge of law and you've got the narrow view and you've got a broad view and you don't know where the better view lies, you can attach your draft advice. You can put forward your views and then seek counsel's opinion. If you've done the work, if it's statutory construction, for example, if you've done the work and there's extrinsic materials that you've found, put them in because it does save your barrister from undertaking that kind of research. Where you're referring to legislation, I recommend hyperlinking to it. I don't recommend having to actually pull it unless it's a particular point in time for some reason. because again, we can access everything these days quite quickly. But again, it depends on the type of matter. I just want to encourage you to start to think about the questions that you want to ask your barrister, and for junior solicitors, it's not just a briefing a barrister is not just an act of compiling documents. You can start to think for yourself, putting yourself in the shoes of the barrister, and think about what you might decide forensically, strategically, or in terms of the advice for yourself, and then you can test it with that barrister.
And I think a point about actually the construction of observations, and I'll detour momentarily, for indexes, think about whether or not someone wants electronic or hard copy and ask them. Most people should not be demanding hard copy these days, frankly, but nonetheless, if they want hard copy, then that's okay. Again, it's a cost-conscious thing for a client sometimes.
I've been told to ask for anyone who does a hard copy brief on the spine, where you might say it's a brief to, for example, Nicholas Olsen, please write who it's from, because if we've got a bunch of hard copies on our shelves and we want to navigate to the matter, and just seeing our own name is not much assistance to us, but seeing your name is exactly what we're looking for. So that's one point that I've been asked to relay to you all. And another is actually there's mixed feedback on the floor. Some people will say, I just want a single link to a single PDF that's bookmarked. But then others prefer the individual files in PDF. So although I love a single PDF that's bookmarked, I was in court recently and my leader was being asked certain questions from the bench. And of course, I'm pulling up the relevant documents for him to be able to assist. And when I realised I was in just one single PDF and I wanted to be in a few of the bookmarks at the same time, it was proved difficult. So I realised, at this stage, I probably would have been better off if I had individual PDFs. But when reviewing the brief, a single PDF was of assistance. So it's worth discussing with your barristers. Do you have something to add in that regard?
I was only going to say, currently appearing in a trial with a very large court, which was originally attempted as a single PDF, and it quickly became so large that it just wasn't manageable. So there's electronic court books which have separate PDFs for individual documents are, I think, inherently more flexible. And you don't have that problem of trying to open a 10,000 page PDF, which instantly crashes your iPad
during court.
That's my comment.
I think it's a reasonable comment, and I think one way of perhaps doing it is if you're going to have subfolders, you could always structure it along the sort of topic lines of an index, so that you've got subfolder A, which has all the pleadings, subfolder B, which has critical documents, etc. And that way you're not dealing with 25 or 50 folders that you're looking at to try and work out which folder it's going to be in. I'd also say we canvassed some opinions on the floor in preparation for this, and one thing that did come back which struck me as true was a desire to make sure that if you are going to have an electronic PDF, to make sure that it is bookmarked, but with sort of tab 1, tab 2, tab 3, so that the bookmarks correspond to the actual index. The index can itself be hyperlinked, but if you click in Adobe Acrobat, you'll have a side pane on the right-hand side which actually has the tabs. So it should have enough of a description so that you can identify what the document is, so that you're not navigating back to the index and hyperlinking back down all the time.
I think you need to be careful to avoid email strings.
Yes.
It's a matter of
Certainly.
practice.
Yes.
You'll make sure you don't have them.
Yes, and or my favourite of FYI for your briefs, for your new and individual documents, and then that's a matter for you how you say things.
Email 1 of 11.
Observations. So I was strongly of the view as a solicitor, and I maintain this view now, that everyone in the team has to be incredibly involved in actually developing the case theory and developing arguments about the law and about the evidence. Yes, we're experts in certain things, but the best way, and we'll get onto this in sort of how to lose a case, is ignoring the opinions of people in the team who are lawyers, who are very experienced. Frankly, I found it a bit surprising as a junior barrister to have partners of many years experience saying, what do you think? I do have an opinion frequently, but the fact is that all opinions are valid, and particularly, and I do this in comp as a matter of course, if you've got very junior people who are actually very close to the documents, who are preparing the brief, who are looking through material, I ask them what they think in preparation for whatever it is that I'm doing, because more often than not, they'll have had much more time with things and they might have thought about things that I haven't. And that goes for observations. Good observations can make the process of reading into a brief, the process of preparing something, far better and far more efficient. So structure it in the way that you would structure thinking about the cause of action, for example. The cause of action involves these things. These documents are what we say make up the elements of the cause of action: issue, rule, application, conclusion. It's an IRAC structure that everyone learnt at university. That's a pretty good way to structure things. Structuring it to the extent that it's chronological in that manner is also very helpful. And also provide, if you're not going to hyperlink things within the observations to a particular document, this is put a cross-reference, brackets tab X of the brief, and you'll see, we'll turn to the chronology, because this is sort of how I would do chronologies. The first one is actually the chronology of a dispute, and you can see that just on page 2, it has a date of the particular document or the event in question. It's a board meeting where a particular matter was discussed that's relevant to the claim. Oh, I apologise. Jackie, can you hand out some further copies? In the third column, there's just the source or the evidence, and that's where I can quickly go to pick up whatever it is. And this is the kind of document that I will actually print out and take to court with me, because you might get hit blindsided by a question, well, where do you say this arises? And you can pick it out pretty quickly from a brief, as opposed to going, I know it's in the brief. I think it's probably somewhere halfway down the 4,000 page documents and I'll find it. Give me 5 minutes.
And it's the first document we all draft if we haven't received it in our brief as we're reviewing. We draft a chronology. So if you can draft one with the brief, it's so helpful. And
then notes. I think most lawyers would admit that they're human. And during the process of actually preparing a brief and preparing a chronology, you will come up with ideas about how to construe things, how to interpret things, why a particular thing is relevant. You should include your notes so that we have the benefit of understanding what you think about a certain thing. We'll do our own chronology in the end, not just depending on others' chronologies, but we'll do our own chronology as well, and we'll add our own notes as we go, but this is a good basis to start things with. Do you want to talk about the chronology of steps in a proceeding?
Sure. And I might tie it into observations as well. So where you set out the litigation history or the steps in the proceeding, it gives us an idea of where we're up to immediately, an excellent snapshot. And what I would encourage is that you make very clear up front in your observations what the next deadline is. So if we're due in court, if we're in default of orders, knowing that straight off the bat, as opposed to once you work through the chronology, would be very helpful. And going a step further, well, directions is on this particular date, you're not going to be required to attend, because I, as the instructing solicitor, will, and I'll report to you, or you are required to attend unled or without me, because sometimes I'm finding that out the morning of, and I'm getting better at asking well in advance, but sometimes an instructor might not be able to attend with me, they never wish to attend with me, and then I have to print whatever I might need printed and just do extra preparation. Sometimes you have a solicitor advocate who wants to run things up until a point. So just explaining what you would like from us and when is very helpful. For deadlines that are not related to the next steps in the proceedings, it would be wonderful if you could indicate why the deadline exists. And I don't mean to be cheeky by saying that. It's just that where deadlines are not court deadlines, and we're faced every day with court deadlines, it's always helpful to understand how real the deadline is, or if it's because we wish to have a client conference in advance of them going overseas, or this is presently costing my client this much a month, and this is why it's become urgent, or just whatever it is, because sometimes you get told of a deadline and it might be arbitrary, or it might just be an ideal scenario but not what is needed. And conversely, when you understand the realities of the client or your workload, we might decide, oh, let's get this done even sooner, and let me reprioritize everything else. So just being really honest about deadlines, and also limitation periods. They sneak up on us. I'm sure they don't sneak up on you as much, but it's something we might only become aware of once we reviewed the entire brief. So if you could put them in the outset in observations, and again, the basis upon which, because sometimes calculating limitation periods is a complex exercise, and then we can still exercise our judgment as to the limitation period, but that would be helpful. I was going to mention it would be helpful if there's a particular billing cycle or billing arrangement with your firm, if you could indicate that in your brief, because sometimes we don't know, and then we have to find out later, and things can get complicated, and people don't always like to talk about money anyway. So it would just be nice if you could let us know when and who to bill.
Noting, of course, that our contract is with the solicitors, not with the client. So, for example, if there's a concern that you have about whether or not the client can actually pay, and you obviously need money in trust, let us know. I think it's conducive to a very good ongoing working relationship if no one ever has to talk about money. And certainly no one ever wants to be chasing anyone for money. It's a kind of grubby part of the job.
Shall we talk about how to lose a case, Owen? Because that's what you're all here for, I'm sure.
Sure. I think so. We're obviously all here because we want to win cases, but there are very straightforward ways that I suspect that people can lose cases. So the first one that I know that we probably disagree on is have a really big team. And I'll explain why I think that's a problem. I think people lose track of communicating in very large teams about who's doing what. You don't necessarily have the people who need to have a focus on a particular issue focused on it until the very last moment. You can create silos in large teams, and you don't develop the institutional memory over the course of a case that allows you to be pretty nimble when it comes to actually running the case at trial. You also, I think, and this with no disrespect, I suspect it's something that I did as a solicitor, the bigger the team, the more there are pressures that I understand around billables and your billable hours, particularly if you're a junior solicitor. The more likely you are to actually spend a lot more time preparing very long documents or engaging in doing lots of work that might ultimately not be used as work product. So having a smaller team where you're sort of making a lot of forensic decisions together and everyone knows what's going on, I think is actually a pretty good way to ensure that, you know, errors don't occur or particular material gets left behind in a long running case. It's kind of horses for courses, because a smaller case or a case that's going to be expedited, an injunction, it's not going to involve that kind of problem. But it's something that I think about, and Bianca, you disagree?
I disagree because I've had such a wonderful experience last year working in a very large team. So I think there was 7 barristers at one stage. If it's all barristers. And about 10 or so solicitors. We had a really well-managed task list, solicitor task list, counsel task list. I've now took that with me to a matter in which there's 2 barristers and 3 solicitors, and I did 2 separate task lists because of my experience of it working so well on the large matter. And my leader said, I think we can just do the single task list. There's only 5 of us. And I said, yes, of course, my apologies. And it was so well managed. And because new documents were coming in every day during the trial, a group of us were working on cross-examination prep for each day. and then others were working on a review of new documents coming in each day, and then there were others managing all sorts of other matters of the trial. So because I've had that good experience in working as part of a large team, there were 2 partners, 2 different cities, and even their solicitors working on different things, I would just say I don't think the size of the team is determinative of how effective the matter can run, and it depends on the size, and it depends on the volume of work that's achievable and has to be humanly possible. And I think at some point someone was always awake over the 24-hour period. So I think that's why I disagree. But otherwise, yes, it's always good to be as involved. It is nerve-wracking when you're not across absolutely everything. In an ideal world, we're all across absolutely everything, but sometimes we just have to have faith in everyone doing their part of the teamwork.
Have a team that doesn't trust each other. So this is a little bit contentious, but I suspect most people have been in this type of litigation team, combination of solicitor and counsel, where particularly where more senior people, usually not solicitors, more senior counsel come in and out, and they have different views about how the matter is being run or certain forensic decisions that have been made. It is not conducive to the successful running of a matter for people to not trust one another. It involves a lot of hand-wringing at the end of the day, and second-guessing and changing forensic decisions, and a lot of sort of work being thrown out, perhaps. If you find yourself in a position where you think, well, counsel isn't trusting what I'm doing, or you're not trusting what counsel is doing, I kind of think it's better to have it out and to have a hard, awkward conversation than it is to constantly sort of second-guess through the process, because it might be a misunderstanding, and a misunderstanding can often be sorted out. Have a team that doesn't know its skill limits. You have any views?
Yeah, I do. So I think something that's really interesting I've noticed now being at the bar is I'll have some instructors that wish for me to draft proposed orders, to draft proposed correspondence, and others that just want it to be settled, and some that don't even need me to look at it and will just inform me and say, this is where we've landed. So, I mean, that ties into knowing your own skill set, but it's also, I think I just want to encourage instructors to have a conversation with their barristers about what they do and don't know. So I've got one brief where an instructor has no experience in a particular area of law, but this client is a long-standing client and there's this ancillary issue that's in a different area. And so that's what I'm there for. Whereas now that I'm involved in another dispute with the same client, she can run that entirely. Where I have junior instructors who want to learn, I'm grateful for those types of conversations, because then I might say, would you like to have a go at the first draft of X? And it's in a psychologically safe environment that they have a go at it, but rather than it just getting palmed off to their barrister. So I think just being really open and honest about it, and that works both ways. So I'm a reader, so I might be briefed in an area that I haven't worked in before, and I'll let the instructor know that, and the instructor often might say, "Oh no, I'm completely okay with you spending X amount of hours getting up to speed on this and that, or I'm an expert in that space, but I'm not an advocate. I don't wish to be an advocate, or it doesn't suit this type of matter for me to spend a day on my feet. And I'd like, and it works for me to palm that off to you and for you to be the advocate."
Or I hate pleading, and I don't like pleading statements of claim.
Or I'm not really comfortable with admissibility, and I find that I have to redraft affidavits so many times that it would make more sense to have you in the witness conference and my junior to type up notes and for you to settle that, because that's more efficient, and because we should be experts, say, in evidence law. So it's those types of conversations where I can understand how you wish for me to assist. I can understand your skill set and you can understand mine. I think that's really important, and I think that feeds the trust. And litigation is stressful, so it's nice when you have rapport with each other and you can work well as a team.
I think it also connects back to what I was saying about sort of 3As. If you have a particular counsel team who think that they're the modern day heirs of Cicero, then, they're more likely to actually make errors because particularly busy people will overlook things or they'll believe that things are particularly beneath them and they won't sort of prepare. That's how you make errors. I think knowing actually my skill set is not really doing this thing and being upfront about it is a good way to ensure that work gets done properly and efficiently to the interests of the client. And to assist the court too. Have a paper allergy. Now, we've talked a lot about electronic briefing, so this is a somewhat sort of idiosyncratic view, but be prepared to read the papers. It's absolutely essential to avoid coming up into trial having had a large brief thrown your way, if you're talking from the counsel's perspective or from a solicitor's perspective, and finding yourself hit with documents that you didn't know existed because you didn't actually sort of sit down and read them. That's an expensive process. We have what might be described as a Rolls-Royce justice system in Australia, and it might be unfairly said that that's only available to people who can afford Rolls-Royces. But I think you just need to advise a client very early on that it's going to require you getting in depth in whatever it is that they are coming to you for legal advice about. You're providing a service, you're providing skills as an experienced practitioner, and being across the material is absolutely essential. That's what we got. Use other people's chronologies. Well, I mean, this is sort of counter to exactly everything that I've said before.
Well, we'll use yours because we're a team.
Yeah.
Yeah.
But also expect that you'll see on the bill the preparation by counsel of their own chronology, because that's how I personally get across something. I work out what's happened and when. And it's not a disrespectful second guessing of someone's work. It's simply working it up so that you actually prepare in your own mind, because ultimately Bianca and I and Nick are the people standing up in court and making excellent arguments or making fools of ourselves. And the easiest way for us to make fools of ourselves is for a judge to go, well, hang on, such and such happened, and that's in the other side's documents. And you go, oh, well, you look around forlornly for someone in the courtroom. You're in the loneliest spot in the world. And there's nothing to be done. So prepare your own chronology. Work with counsel who are too grand to worry about bundles. Back to the 3As. It's about reading the papers, but it's also about preparing things. If you, as a junior paralegal and graduate and lawyer, we were always responsible for preparing bundles, preparing briefs. It's an unenviable task. You're the person who, at a very junior level, is often being asked to identify relevance or identify in something that is critical. So work with a SILK who's prepared to grab the brief and go, that doesn't work there and this works here, or who at least is going to ask you for a big bunch of critical documents and then they'll work it out themselves because they need to be across the material. Bundles aren't glamorous either, but they're essential.
They're our friends.
Yeah. Make sure unglamorous work is done. Now to requests from the floor, that involves spines on purpose. And speak, we've already said it, but speak with counsel well in advance about how they want things. It might be that they require certain things in a certain way, but that's not how your firm or you personally do it. It's probably worth discussing whether or not the way that you do it could work for them, or if they are steadfast in their ways, providing it in the way that will work best for them. Ignore the facts.
I think sometimes we wish to please our clients or please our instructors, and that's not the job of barristers, not the job of lawyers. And where something is likely to, where a matter is likely to lose, or where something is likely to go against our client, delivering bad news, hard, cold, and getting it done is really important. Having matters that, and I've seen it, I'm living it at the moment, that might drag on because of, say, clients being steadfast or stubborn, it's our job to ideally dismantle that or to assist in being an advisor, being counsel, but not being not just going along for the ride, no matter how ambitious a client might be in their commitment to taking something as far as possible. Because the facts will remain how they are, they won't change. No matter how persuasive one can be, you are only as strong as your evidence, and we can all do our best, but if the evidence and the facts are against us, then they simply are. Is that what you were intending there?
Yes, and it follows on to the law is not like maths. So you might, we were talking earlier about short judgments, you might see now sort of what's called a lop and flop, which is losing party's case, winning party submissions, analysis of the law, conclusion. That's what a judgment sort of now follows as a rough rubric. But that gives it a schematic that betrays the fact that usually, having case managed a case, a judge has an outcome in mind. They will ordinarily think that they know who won and they'll work through that. But that involves sifting through human experience, how someone performed on the stand, whether or not someone was credible, if it's not a credibility issue, whether or not the effluxion of time for someone's memory means that perhaps their evidence is not going to be as preferred. That's not a mathematical exercise of this fact, this fact, this fact equals X conclusion. It's not a simultaneous equation. So don't treat the law as if I just get these things together. I'll give you an example. I've got a case, I won't say which one it is, and fall into the barristers' predilection of talking about their own cases, but a case at the moment where I think we've got a fairly good case on the documents, but there's a series of alleged implied terms from the other side. My client's evidence at a distance of about now 8 years is I wouldn't have had that conversation. No, I wouldn't have. No, did or didn't have that conversation. And I reckon there'll be a terrible witness in cross-examination at the end of the day. Because they won't have a memory of it, but they might want to go into evidence in preparing a proof. So you need to appreciate that you're dealing with humans who have disputes, and that involves a degree of uncertainty that you're always going to have to be very comfortable with. And being aware of that at the outset, particularly when you're sort of first talking to a client and then working through the process, is I think, a good way to avoid losing a case.
So now to win.
Oh, now to win.
Well, we can't really, that might be its own topic.
That's not what I'm not going to offer advice about.
That's I don't think there is any hard and fast rules about that. Well, maybe. Anyway, in terms of getting the most out of your barrister and working well with them, coming back to the ingredients of the brief, the order of the brief that we've canvassed, there are additional materials that are in the New South Wales Law Society booklet that I understand Jackie would have circulated a link to, but also the New South Wales Bar Association have a guide to briefing a barrister. There are other template examples that some of them relate to particular subject areas that I found quite useful. Until receiving Owen's lovely chronology and templates, I used the templates that were on the Bar Association's website for chronologies. I also like the blue colour that they use there. I think what's really nice is to set everything out that's relevant to your barrister and then lock in whatever might be the next key date, whether it's a conference next week, which turns their mind to having reviewed it by that particular point in time, setting up task lists or asking your barrister to do that. That depends on the size of it and the level of your barrister. Explaining to them what it is that you would like them to do as opposed to what you or your team would might manage in terms of the teamwork and the tasks. And just having an environment in which you create the trust, but you also manage expectations. You deliver the brief in a manner that is how they would like it, so that they can, you know, voraciously read it immediately, and just to be able to meet the next steps efficiently.
I think it's a very good discipline to also ask in advance, particularly if you think I'm going to brief this person all the way through to a trial, and I think I'll get trial 2 years down the line. What have you got booked in? Because you might, like Nick, be in the middle of a 6-week long trial.
14 weeks.
Oh, I apologise, 14-week trial, which involves a lot of preparation beforehand. So it's not just 14 weeks, it's months before that. And 2 years ago, that might have been booked in, that might not have. If it was booked in, then a pretty human reaction is I get a call saying, yes, oh yeah, absolutely, I'll be available for this. And then 2 years hence, just having done all the work, having read in, having understood the case, developed the case theory, done the pleadings, prepared the evidence, all of a sudden you're not available for trial because the trial gets set down. So having some sense of availability early if it's possible, and we might not be able to give you that guidance, is useful. And I think, to Bianca's point also, lock in the first thing you want us to do after the brief is prepared and delivered. That might be a preliminary conference to discuss ideas. It also then sets a timetable for us. You want to have a conference in 2 weeks' time. That means this can't just sit on my shelf whilst I do other things. It means that I have to read in, collect my thoughts, prepare whatever it is that you're asking for, at least in draft form, and be in a position to be able to actually assist by then. So I kind of think that's all from us, but
Are there any questions?
Are there questions or observations? Yes.
Nick?
I have a tip I would add, which is, I think in a lot of cases, it helps if the solicitor can facilitate direct contact between the barrister and the client. It's not necessarily the traditional way that things work, but when you are in a position you're trying to prepare cross-examination about a topic or do submissions about a topic, particularly really technical areas like medical negligence cases or IP cases, for the barrister to be able to speak directly to the client, not sort of filtered through the solicitor obtaining instructions and passing it on, can be really crucial to enabling the barrister to understand the nuts and bolts of the case. So I'm doing a defamation trial at the moment, which is about medical negligence, and the other barristers and I spend hours daily speaking to the surgeon that we're acting for, basically getting him to teach us orthopaedic surgery, because that's what we need to be able to cross-examine the witnesses and the experts for the other side. And if we were sort of using the traditional system where we tell the solicitor what we want and the solicitor speaks to the client and gets instructions and then passes it back to us, it just doesn't work. So
it's less efficient.
Yeah, so I think you spoke about siloing earlier, and those sort of cases really emphasise the need to break down those silos and just sort of put people in contact with each other and let them have at it.
It's another rule of how to lose a case, actually, that in preparing for cross-examination, and this also goes to the point about ensuring that everyone on the team is involved. It's not just our job. So the most efficient and effective teams that I've ever worked in for trial have been where we're all together in a room, solicitor and counsel team, and we do a page turn of the affidavits. It's usually everything by affidavit. Increasingly in Victoria, they're starting to move towards viva voce evidence in chief, which scares me. But going through it and working out line by line what a cross-examination point is, and invariably, if you leave someone alone, they will not come up with all the points that they could possibly cross-examine on. You will be able to identify, well, hang on, isn't that document going to be an issue for us, or isn't that document going to be assisting you in this point, or actually you could go off on that path. And so I think one way of how to lose a case is when you're preparing for trial and preparing for cross-examination is sort of doing what Nick's talking about, which is filtering. If you filter, things will get lost in translation. If you're all together and you're actually working through things, you can actually develop the expertise that you need in particular circumstances, and you can avoid missing critical things. Sorry, I was going to ask people questions. Are there any questions online? Oh, fascinating.
I have one request from a clerk. I think it's very important within the process of briefing a barrister. Sometimes it can be a relationship that is quite long, over a number of years with some matters, particularly larger matters. And engaging with the client in a helpful way can often mean that you're more likely to get the availability that you require, the documents handled in a way that works best for you, and a better outcome overall, and a more cost-effective outcome overall for the client. I think that where, from time to time, in my experience, I've seen matters go a bit pear-shaped, has been because that communication really breaks down. And just a hot tip for everyone listening, when a barrister is in court, they can't talk to you on the phone. It's very discourteous to the court, and I'm pretty confident the judges would not look on it fondly, and if you know, it would be an interesting vibe. They're like, oh, I'm just going to take this call. Apparently it's urgent.
I'd have some concerns about a barrister.
Yeah.
There was, yeah.
Just in terms of AVL, it's a bit on that point. Is there a preferred method of communication between instructing solicitors and counsel, like say a group chat or something?
In court?
If it's by audio visual.
Well, so it's a remote, so
This is interesting.
it's a remote hearing and you're actually working out how you can correspond.
Yeah.
My preferred method is WhatsApp. It's a WhatsApp chat that's set up the night before or the day before. It's how I obtain instructions.
However, I would love if my mobile number could be deleted afterwards because I haven't been able to ask that. And then what's happened is I'll just get calls or texts at odd hours from like thereafter. And that's not ideal.
I haven't had that experience, but and I should say I probably would only disagree in that I think my mobile's sort of up on the website for people to call me, so that's my own fault if that happens. Yeah, I think the answer is it kind of depends on what works. One qualification to that is don't have a Teams chat going on, obviously enough. The associate should be able to shut off the ability to actually have comments. I have seen it, and people sort of start typing and making comments in the actual link for Microsoft Teams for a hearing. It's unprofessional. That's the way I'll put it. It's just unprofessional.
And in terms of the WhatsApp group, sometimes it's worth you managing a separate one with whether it's your experts or client team, as opposed to the one with your barrister.
Don't put the client in the
But it depends,
unless they're a very sophisticated client.
Which might be a lot for you to manage, but I find that works best.
We seek instructions from you. You obtain them from the client. That's the way it works, unless they're a particularly sophisticated client who are very invested, because ultimately, if you're standing up, whether it's AVL or it's in person, and you've got your WhatsApp going crazy because the client you have to understand, everyone understands this, it is the most stressful day of their life. They do not interact with the justice system on a regular basis. They don't want to, they don't want to have to, unless they're Clive Parker. And fair play to all the defamation lawyers in the room, he puts down who's who that litigation is one of his hobbies, so that's not defamatory. But it's the most stressful day in their life. They will want to emote throughout the hearing. That was a lie. Ask them that question, this, and this, and it can only really be distracting to the flow of what's going on and to your ability to actually listen to what's happening from a witness or in the box. I don't think it can be conducive to actually success.
And think of it as the equivalent of writing a note and handing it up. So it has to be
Short.
worth that interruption. I think it's easy for everyone to have commentary. I remember once our client team was like 12 people, and this was just at a conciliation conference. And we had them in a room, and and 4 of them were lawyers, but they were the client team, and they had so many suggestions for counsel. And I would nod and absorb it as much as possible and validate their comments. But the amount of comments that then made it to the post-it note was a really small proportion. And that's a really important role that you play during hearings, just to absorb some of that and then to filter through what actually is useful or necessary or of assistance to counsel.
Yep. I think that's it, unless there are other comments or questions. No. Well, congratulations on obtaining another CPD point. And thank you very much for attending this evening.
Thank you.
Thank you.